everyone, we're going to get started. Thank you and welcome. My name is Erin Murphy. I'm a faculty member here at the law school, and my research focuses on forensic science, among other things. So I'm absolutely thrilled to moderate the forum here today. We have a stellar panel, and what did I do with my copy? Although we are not just going to talk about this amazing book, I do need to hold it up for you. See, it even makes the microphone jump. The Cadaver King and the Country Dentist. This is the recently released book by the authors to my left, who I'll introduce in just a moment, and I really encourage you to pick it up. It's incredibly compelling and really in depth will go into the themes that we're going to touch on today. We're going to have, hopefully, just a kind of informal conversation with our panelists. We don't have a rigid agenda or structure, and we're going to leave plenty of time at the end for your questions. So as we go along, please hold your questions, but know that there will be time to ask them at the end. So I'm going to start my introductions with the person immediately to my left, Tucker Carrington. He's the founding director of the Mississippi Innocence Project and the clinic at the University of Mississippi School of Law. Do you go by MIPS? Do you call yourself MIP?
MIP.
Yeah. MIP's mission is to identify, investigate, and litigate actual claims of innocence by Mississippi prisoners, as well as advocate for systemic criminal justice reform. And they have, in this role, Tucker's helped to draft and pass into law Mississippi's first ever DNA preservation and post-conviction testing statute, as well as the state's first compensation legislation to aid those who've been wrongfully convicted. I counted 5 exonerees that are the work of your project alone. Is that right?
That's about right.
And there's even more from the state of Mississippi, which had been aided by the New Orleans Innocence Project prior to Tucker's founding of the Mississippi Project. In 2010, he co-directed the documentary film Mississippi Innocence, which was featured as a selection of, which is a featured selection of the American Constitution Society and screened around law schools in the country. His scholarly work covers a range of criminal justice issues, and prior to Ole Miss, Tucker was an attorney and a supervisor at the Public Defender Service in D.C., among other jobs, and it was there that he used to boss me around, but those days are done. Next to his left is Radley Balko, who's probably familiar to many of you as an opinion writer focusing on civil liberties, the drug war, and the criminal justice system for the Washington Post. He's also the author, in addition to this book, he's also the author of a critically acclaimed book, Rise of the Warrior Cop, The Militarization of America's Police Forces, another great one for those of you interested in these issues. He's the winner of numerous distinguished awards for his work as a journalist and writer, and prior to the Post, he wrote for both the Huffington Post and for Reason magazine. His work has been cited by many courts, so he's not just writing for popular audiences. Legal audiences have appreciated it, including by the U.S. Supreme Court, and I actually looked up your citations,
Both dissents, unfortunately.
I was going to say, and we share the dubious honor of having our work cited in a dissenting and concurring and not majority opinion, or a majority but for the wrong reasons. Another fun fact I didn't know, which is that he occasionally writes about the music and culture of Nashville, where he lives. And last is Bennett Capers, who is the Stanley A. August Professor of Law at the Brooklyn Law School, where he teaches a bunch of courses such as evidence, criminal procedure, and criminal law. His academic interests include the relationship between race, gender, and criminal justice, and he's a prolific, and when I say prolific, I mean prolific, it's a full-time job keeping up with his work, writer on these topics. He's written in about every scholarly journal you can imagine, as well as publishing in the popular press. He's co-editing the forthcoming book, Critical Race Judgments, Rewritten U.S. Court Opinions on Race and Law, with some other stellar legal scholars, and that will be published by Cambridge University Press. Prior to teaching, he was a U.S. attorney in the Southern District of New York for about 10 years, and also had a couple stints in private practice. And he has served in numerous professional roles, including 2 appointments by Governor Cuomo to serve on judicial screening committees, and an appointment by Judge Scheindlin to chair the Academic Advisory Council, which assisted in implementing the remedial order in Floyd v. City of New York, the stop and frisk case here. He's also served as a commissioner to the New York City Civilian Complaint Review Board. So as you can see, we've got some incredibly credentialed people. I want to start just by setting the stage with you, Tucker and Radley. This book is really several books in one. I mean, it's an impressively concise recitation, not just of the two cases that are the kind of architecture of the book, but a real history of the forensic science in general and of the criminal justice system. On the surface, it tells the story of two murders and the men that were convicted for those murders and what binds them together. But at the sort of deeper level, it talks about the deep dysfunctions of the death investigation system in Mississippi and in the criminal justice system at large, including the racism that midwifed those dysfunctions, and the legal and other officials who turned a blind eye to them. So I wonder if you could start by telling us about your work, what led you to write the book, and maybe in the course of doing that, just sort of set the stage for the two cases of the book, the Brooks and the Brewer case, as sort of the entry point here.
So I first was turned on to the story about 12 years ago. I was writing, I was in Mississippi to do some reporting about a case of a black man who had shot and killed a white police officer during a drug raid. And from all signs that the police actually mistakenly raided his house, and he had been sentenced and convicted and sentenced to death. And there were lots of red flags about the case, and I wrote about it pretty much at length over the years. But the one part of the case that ended up sort of being the nugget that ended up being this book was that the medical examiner who testified at trial gave some testimony that was scientifically dubious. Corey May, the guy who was convicted, claimed that he was laying on the floor as the police officers kicked down his door, and he thought they were armed intruders. And then he shot and killed the first one in, and then immediately surrendered with bullets still left in his gun. The police claimed that he had been laying in wait and ambushed one of the police officers. Now, why someone would ambush police officers and intentionally kill one of them and then surrender with bullets still left in their gun, despite having no criminal record or no drugs in the house, I don't know. But Haynes' testimony at trial was pretty critical because the verdict turned on whether or not the jury believed Corey when he said that he didn't know these were police officers. And Haynes testified that the bullet trajectory in the body of the police officer was going down instead of up, and therefore he could only have been sort of laying in wait, or he posited that it was consistent with someone laying in wait to ambush. Other medical examiners I talked to said that isn't necessarily true. In fact, there are a lot of variables that can affect the trajectory of a bullet, including the angle the gun's at, and in particular the position of the person who shot. Somebody who's crouching, for example, you can shoot from below them, and when they're sort of laid out on an autopsy table, the projection of the bullet will look much different. As a journalist, I learned that when you find one example of this kind of thing, in this case, sort of dubious scientific testimony, it probably isn't the only time it's happened. And so I started calling around and calling other defense attorneys in Mississippi, and pretty much everybody had a story about Dr. Hayne. And then I started calling medical examiners in other surrounding states, and it was pretty amazing. I mean, I didn't even have to finish my sentence. I would just say, I'm a journalist looking into a questionable medical, and they would say, oh, you're talking about Stephen Hayne in Mississippi, right? And it was pretty remarkable because there was nothing about him out there. I mean, there were lots of articles about him because he had testified in about 80% of the homicide cases in Mississippi over 20 years, but nothing really critical of him and nothing really critical of the kind of testimony that he had given, despite the fact that everybody sort of knew that he was a problem. In any case, I started writing about him. I had a first sort of long piece I wrote about him appeared in Reason magazine, I think in 2007, which was about the time Tucker started up the Mississippi Innocence Project. And that was when we sort of first had our first phone call. And then over the years, we've just, Tucker has given me sort of tips on cases he's working on. And we've talked, at length about what was going on here. And it, became clear to us that this is a huge story, more than just about a few cases. This is about, really goes to the fundamental sort of, kind of the embodiment of justice in Mississippi and in a larger sense, I guess, in the country. And I guess a few years ago, we just decided that, somebody had to write this story in full. Articles, you can only say so much in an article, even online, when you have the freedom to write at length. We wanted to tell the whole story, sort of everything that kind of contributed to this. We realized we were probably the only two people who could tell it in full, and so we agreed to do the book, and that's kind of where we are.
Radley did call me, and I had just opened up my office literally at the law school at University of Mississippi, and I didn't have any cases. I didn't have much of anything. I didn't even have a computer, and the law school had carved out. They hadn't really. But it sounded like a good idea to start an Innocence Project, but they hadn't sort of thought about the practicalities of such, including that I would need a place to sit and work. So they took a portion of the faculty library and carved it out as my office, and it had a half wall, and my desk and computer were on one side, and the phone was on the other. So for the first couple weeks when I had nothing to do, so to speak, people would stop by and introduce themselves, and I'd have to sit up and pretend like, I was taking on substantive work. The phone rang one day. It turned out to be Radley, but the phone was in the other side, so I scrambled as quickly as I could because it gave me some legitimacy that the phone finally rang in my office. And Radley, being the incisive journalist he said, "What are you doing?" And to which I said, "I have no idea I don't know what I'm doing." But that was in August of 2007.
Maybe if I can interject, can you speak for a minute about the reception you got when you reached out to Mississippi's criminal justice officials about your new project, the enthusiasm you were met with?
Yeah, I might have to actually, let me,
Well, while he's looking that up, I'll just say, at risk of embarrassing Tucker, the lack of privacy that he had at the time makes it even funnier. That is the first thing he said to me when I said, sort of, "What are you working on down there?" was, I'll censor myself since, he said, "God, this state is so effed up," without sort of feeling me out. It was clear he was frustrated from the start.
I really like Mississippi, though.
I do too.
I'm glad I moved there with my wife and kids. In any event, part of my job was, this is a segue from my segue. Part of my job was as a sort of mini PR firm, and I had to introduce the newly formed Mississippi Innocence Project to various and sundry people around Mississippi. And I got the great idea that I would draft personal letters to every member of the Mississippi District Attorneys Association, which went over like a lead balloon. Anyway, in the introduction, Professor Murphy was asking me, somehow that fact combined with the establishment of the project meant that many prosecutors across the state who were graduates of the University of Mississippi School of Law were, quote, naturally concerned that the law school is impugning our integrity, wrote one district attorney back to me. Another district attorney wrote a letter. He noted that over the course of America's 230-year history and among its population of 300 million, quote, there is a claim of only 200 wrongful convictions. Where's the problem? He also suggested that instead of an Innocence Project, the law school should start and I quote, the Guilty Bastard Got Off Free Project. Anyway, in early 2008, the Innocence Project here, at Cardozo, had been working on a case. Kennedy, the name of it or the name of the defendant is Kennedy Brewer. They had been working on Mr. Brewer's case for 4 or 5 years, and Mr. Brewer had been convicted of sexually assaulting and strangling a 3-year-old girl in a small isolated community in Noxubee County, Mississippi, which is it borders Alabama, east central Mississippi. And he had gone to trial and been sentenced to death. And the main piece of evidence against him had been bite mark evidence, forensic odontology, bite mark matching. And the star prosecution witness was a guy named Dr. Michael West, who matched bite marks on the 3-year-old victim to Mr. Brewer. In any event, the Innocence Project in New York had been working on that case for years, and they invited me actually to come down to a hearing in, I think it was in August of 2007, September 2007. Long story short, later, actually the first part of 2008, after they had asked for post-conviction DNA testing, the DNA testing came back in Mr. Brewer's case and exonerated him and identified third-party perpetrator individual. At the time, initially, they didn't know who it was. They didn't, but there was a companion case to Mr. Brewer's case, and that was the case of LaVon Brooks. LaVon Brooks had been convicted about 18 months or so before Mr. Brewer had, also in Noxubee County, and I don't know if anybody here is familiar with that part of Mississippi, but this is a really rural, isolated, not at all densely populated place. Mr. Brooks had been convicted of an astonishingly similar offense, the abduction, sexual assault, and strangulation of a 3-year-old girl. The incidents happened about 8 miles or so as the crow flies from one another, remarkably similar cases. The Innocence Project, Peter Neufeld and Vanessa Potkin, who were the lawyers in the case, felt like it was quite possible that the same person had committed both offenses. Mississippi authorities found that to be impossible because they had convicted LaVon Brooks, locked him up, and yet this happened again, so clearly there was like a copycat person out there, not the same person. In a sort of remarkable turn of events, the DNA in Mr. Brooks's case had degraded, and so it wasn't able to be tested. But I won't get too much into the weeds of the facts of the case, except to tell you that ultimately the DNA analyst was able to figure out who the specific individual was from the testing in Mr. Brewer's case. He still lived in the community down there. Law enforcement went out. He knocked on the door. He answered it. They asked him if he was Justin Albert Johnson. He said he was. They said, "We need to speak with you." He pretty quickly admitted to being the person who had abducted and sexually assaulted the little girl in Kennedy Brewer's case. He hesitated briefly, and I think he actually denied it for a minute. But then within 30 minutes or so on the drive to the jail, admitted that he had also been the person who had abducted and sexually assaulted the little girl in the Von Brooks's case. So suddenly, the Innocence Project had on its hands not only one exoneration, but two. And circling back now to finally answer your question, the person who had testified in Mr. Brooks's case, the forensic analyst, Dr. Michael West. The main piece of evidence, bite mark matching. So not only had the Innocence Project sort of exonerated two people, they had uncovered what Radley and I write about in our book, which is, strictly speaking, this reign of Dr. Stephen Hain, who was a pathologist, and his sidekick, Dr. West, the forensic odontologist, and their work in Mississippi, and then more broadly, as you mentioned, forensic science issues nationally.
So I want to get to Hain and West and the origins of the death investigation system and sort of how they were able to flourish. But first I want to bring Bennett in. And, you know, from your experience as a prosecutor, as a scholar writing about prosecution, what about these investigations, but also just what you know about the way investigations take place in general? How, in the wake of a serious homicide, police behave, how they investigate a case, makes a case vulnerable, both to the kind of spurious claims that these forensic specialists gave, but also just to wrongful convictions overall. What are the red flags or the things you have to look out for?
So great question, but first I'm going to add to what Tucker was just telling you about the case, only because I've read the book, I know this. But this Johnson guy, who is the actual murderer of both of these girls, was a suspect from day one. So the police, in both instances, had him as a suspect, but they sort of ruled him out early on for no good reason at all, and instead focused on two other individuals, Brooks and Brewer. So almost from day one, we sort of see this tunnel vision, this sort of like latching onto a bone. I think it's Brewer, and therefore I'm going to build a case against Brewer and sort of exclude all other evidence that might undermine that assumption. And sort of elevate any evidence that sort of supports it. So you sort of see this, you know, all these problems that are, you know, throughout the system. And it's not just law enforcement officers, obviously it's prosecutors, it's judges. So the great thing about this terrific book is, to me, it's not just an indictment of sort of junk science, it's an indictment of the whole system. Like the whole system and I don't want to jump too much ahead, but the whole system seems so corrupt.
We're gonna get there. Let's ease them in.
We're done here.
So the last thing I'll say before, if you aren't from Mississippi, I know you love Mississippi. Don't go to Mississippi.
Well, but let me.
I'm kidding, obviously. but-
Well, let me just, so I want to say a couple things. One is, I think that we see the red flags in the way the interrogation of the witnesses was done, the way the forensics was done in a non-blinded fashion and so forth. And I do want to get to some of that, but I also want to get to not making this about Mississippi, because I think a lot of what happened in Mississippi may be an extreme version, maybe in other jurisdictions, not as many of these problems exist in concert, but it certainly isn't unique to Mississippi. So maybe we could start, maybe one way to drill down more concretely is to hear about the origins of the coroner system or the death investigation system, which is still a dominant way of investigating suspicious deaths around the country, not just in rural Mississippi. Maybe we could hear a little bit more about that as a foundation for those.
Good, one of my favorite topics, the history of coroners. I'm not kidding. So the coroner system is a system we inherited from England, and it's just a crazy system. The English coroners came to sort of oversee death investigations almost by accident, and for whatever reason, we kind of inherited that system here. And it became sort of they would oversee death investigations, and they'd also sort of do a lot of other things that just didn't fit into any other office, and we inherited that also. So in Mississippi, for example, up until I think it was like the mid-90s maybe, the coroner in Mississippi had two jobs. One was to investigate suspicious deaths, and two was to round up any stray livestock that people called in to report. And the two qualifications, so let's also get something out of the way too. A lot of people mistake coroners for medical examiners, and I did before I started getting into all this. A medical examiner is a doctor, a licensed doctor, should be certified in forensic pathology, although Hain wasn't. It's a doctor, it's a person who performs autopsies. A coroner is an elected position. It tends to be a pretty low-level elected position, but given a pretty profound power, the power to sort of oversee death investigations, to determine if the death was a homicide or an accidental death or negligence. And so in Mississippi, you had elected coroners who, for a long time, a shockingly high percentage of them couldn't read. They signed death certificates with sort of an X. It tended to be either somebody who needed the money, which it wasn't very much money, so they weren't particularly qualified, or a lot of times it tended to be the local funeral home owner because there was a financial advantage to being in charge of death investigations because you would get first crack at the family for mortuary and funeral services. It wasn't the person who was best at investigating crimes. That person rarely ran for coroner. And so this system is the system that kind of came to dominate death investigation systems in America. And we get into a little bit of the history, but it became incredibly corrupt in the 20s and 30s. One reason why is because, as you can imagine, how you classify death could alter life insurance payments. It could alter things like negligence claims. So, for example, in the 20s and 30s, factory deaths. If you could, rule that a factory worker who died because of unsafe conditions contributed to their own death in some way, you could get the company off the hooks. There were a lot of kickbacks and money exchanging hands. But in Mississippi, and actually in a lot of northern states too, actually, one really big function of the coroner system, really important function, was to cover up racial violence. And so in Mississippi, you can imagine if you were the coroner, you're the first person who gets to come to the crime scene, you take control of the body, you control sort of who gets access to the crime scene. What we saw over and over again, sort of pre-civil rights era, is that coroners helped cover up lynchings. They would, inevitably, there's a magic phrase that they could use called death at the hands of persons unknown that would end the investigation, basically. And in some cases, there would be a lynching, and there would be a photo in the local newspaper on the front page of all the lynchers posing with the body, and the coroner would investigate and determine death at the hands of people or persons unknown. So there was really no effort to investigate, and it was a way to sort of preserve the racial hierarchy and sort of excuse racial violence. We get to the civil rights era, and the coroners play an important role in sort of thwarting federal investigations of the murder and assassinations of civil rights figures. We talk in the book some of the more famous ones. Reverend George Lee, who was probably one of the first kind of martyrs of the civil rights era, was murdered in Belzona, Mississippi. It's a crazy story. He was driving home from the drugstore he owned when a convertible pulled up next to him and somebody pulled out a shotgun and blew half of his face off. He then sort of crashed his car into a house, and the coroner ruled that he had died from the car accident, and the metal that they found in his head must have been from fillings in his teeth that jostled loose during the car accident, because they didn't want to call this what it was, which was an assassination. With Emmett Till, same thing. The coroner that's there didn't do, well, actually, they didn't order a real autopsy, so that when it came to try the man who killed him, who later admitted to killing him, they could claim that they weren't sure that that the body was found was actually Emmett Till because nobody did an autopsy. I mean, it was a preposterous claim, and they probably would have acquitted anyway, but it gave them something to sort of, hang their case on. And with the murders of the three famous murders, the three civil rights workers in Mississippi that were the basis of the movie Mississippi Burning, the federal government, stationed people outside the door where the bodies were because they didn't trust local officials in Mississippi to, conduct the investigation properly. And in fact, the guy they hired to do the autopsy has kind of botched them, it seems now. So this was the system that kind of is how death investigations were conducted in Mississippi, and we talk about this in the book. It was a system, that basically in the civil rights era and before served to preserve the racial order. That was its main function, and it doesn't get the credit that it deserves. We hear a lot about racist Southern governors and sheriffs, but the coroners played a big role in kind of keeping civil rights at bay, not in the South, but pretty much everywhere. But it was a system that primarily sort of served the people in power. It gave them what they wanted, and that's the system that sort of exists into the 80s and 90s when we start telling this story. And now it's not so much about preserving racial violence as it is about getting convictions at any cost, confirming the hunches of prosecutors and police chiefs. And in some cases even, we talk about, there are a couple of cases, at some point in Mississippi it becomes fashionable for politicians to start reinvestigating those old civil rights cases. And here too, the system kind of facilitates that. And in some cases, these cases ended in a kind of karmic justice, and somebody who should have been convicted a long time ago got convicted. But in some cases, one in particular we talk about in the book, Hayne gave some questionable testimony that gave the federal government jurisdiction to handle this case. And even then, it was sort of an abuse of the system, even if the ultimate outcome, serves some sort of karmic justice. I don't know, is that
Yeah,
good?
maybe we could amplify it too with a bit about bite marks. I don't know, Chuck, if you want to go into that, but so that gives you a picture of how death is investigated in Mississippi and how influential these elected people are in serving up a case, essentially, or foreclosing the possibility of prosecution. You can be the most civil rights friendly district attorney, but if you have a coroner who's telling you this was an accident and I won't, say anything otherwise, you're going to meet a lot of obstacles. So maybe we could add to that the bite marks piece and how West comes in.
Well, as Radley said, by the time you get to the 1990s, roughly, the sort of stark, naked bigotry that paid off for coroners in that system in the 40s, 50s, and 60s wasn't working anymore. That was passé, so to speak. But the system, the architecture of the system was still there. And combined with that, there was, I won't go into it that much, but suffice it to say that Mississippi, for about 2 decades, did not have a state medical examiner. The office was vacant. And so you had the remnants of this coroner system with a vacuum in the medical examiner's office. And what happened was Dr. Stephen Hayne essentially was allowed to privatize the state medical examiner position. He worked out of a different county. He worked out of the back of a funeral home. He was not in Jackson, which is the state capital, at the state medical examiner's office. And as a consequence, there were a host of incentives that arose. Broadly speaking, what was incentivized was efficient prosecutions. And then one of the sort of sub-incentives, if that makes sense, was unsound forensic disciplines. And one of them, which has gained quite a bit of notoriety around the country, is, and I've already mentioned it, bite mark matching. There are others that have recently, there have been some terrific articles. There's a big hearing in Texas last week or the week before on blood spatter. there's a gunshot, ballistics evidence. There's a host of them to the extent that you're not familiar with them. But one is bite mark matching. And as it happened, and to get back with our underlying theme of Mississippi, one of the things about Mississippi that's so intriguing is that it produces, and I say this, I'm not being facetious or anything, it produces extraordinary stories. William Faulkner, Eudora Welty, you could go John Grisham, who wrote the foreword to the book, on and on and on. The stories, those are mostly fictional I'm talking about, but there are nonfiction stories which are incredibly illustrative. And just like Faulkner, not to lecture, not to be an English professor up here, they still have deep relevance. And in any event, Michael West was a sidekick, colleague of Dr. Haynes. Over the years, he began to hone this discipline of pattern matching, bite mark matching, and he was extraordinary for a period of years at what he did, or at least he was thought to be extraordinary. And he was I won't get into this now, but he became one of the leading forensic odontologists really in the world, certainly in the nation. Query how that could be, and query what the national sort of governing boards have done with that news after the exonerations of Brooks and Brewer and others in Mississippi. But in any event, Dr. West, as I said, matched the bite marks in Brooks, in Brewer, and several other death cases. I don't know. I argued in front of the Mississippi Supreme Court about 2 years ago and felt safe saying, I'm pretty positive that Michael West has never been right as a forensic odontologist. And I think that's an objectively verifiable claim. And it's both, darkly funny at some level, but also really shocking. I mean, there are people we have a client still on death row and one who just got off, but these are, over the course of 20 years, if Dr. Haynes is doing 80% of the autopsies and he has Dr. West working with him, you can imagine sort of the wake of destruction that the two left.
Well, I would argue that West has been right in a couple of cases, because when he said that this bite mark was created by the suspect's teeth, because we have video in cases where he took a dental mold of the suspect's teeth and used it to create bite marks on the corpse that he later then testified were a match to the suspect's teeth. Now, he probably got the wrong person in those cases, but there's no, that's remarkable. We have that video, and not only is West, not in prison, but the guy he convicted in that case is still on death row in Louisiana.
So Bennett, I want to turn to you again about the system, but just to point out a few things for those who haven't read the book. If we spent the whole panel just talking about Haynes and West, we'd still not have enough time. But there were ample red flags here, and you'll see that when you read the book. In terms of Haynes, the death investigator, for instance, I think at one point one of the professional organizations says you shouldn't do more than 300 autopsies a year. He's doing 300 a month. I mean, he's clearing unconscionable numbers of cases that could never be performed with any minimal level of competency, even if he had credentials. He fails the equivalent of the bar exam for his job, and then he says, I had a question I didn't like, so I walked out, and it turns out that question wasn't even on the exam. There's just the number.
Try that on the bar exam.
That will not work. He's got all kind of shady financial dealings going on. Same thing with West. I mean, West is doing all kinds of completely manufactured experiments involving ultraviolet light and silly putty and overclaiming, just making up numbers out of thin air. And one thing that's interesting is how different their styles are. Haynes kind of more cautious. He's the kind of credible person on the stand who seems reserved in his, I'm sort of implicitly telling you what to believe, whereas West, I gather, was much more flamboyant and ostentatious. But they were both able to succeed, which is a huge indictment of our system. And both of you alluded to the fact that in many ways the system was working as intended, which is to say it's a direct outgrowth of a system to maintain white supremacy in which we don't want real coroners, real death investigations, real investigations, that I think in the way you put it morphs into a system largely about confirming the hunches and suspicions of local police and prosecutors. So I want to bifurcate that as we walk through the kind of people in the system, because I think there's still a story of racial injustice and white supremacy that underlies this hunches and suspicion model. But then there's also a story that applies to everybody, or certainly those without power, regardless of what color you are, and is about the way our system is designed. So if we look just at judges, prosecutors, defense lawyers, even the media, you've got pretty strong indictments for all of them. Maybe I'll start with you, Bennett, in just thinking about what is a judge's role supposed to be in this capacity, both supervising scientific evidence and maybe there's the trial process, more at large, and how is it failing, not just in Mississippi, but all over?
So, since the Supreme Court decided Daubert, the judge is supposed to be a gatekeeper, so sort of like patrolling what kind of expert evidence is allowed, what expert evidence is not allowed. So before the jury even gets to hear what the expert wants to say, the judge is supposed to do screening to make sure that the expert testimony is really based on something that sort of can be tested. There's actually some real science behind it in this case. And what we see in the Cadaver King book is judges just failing all the time to do any gatekeeping. What they're really doing is sort of saying like, oh, okay, well, the prosecution, I'll let you call your expert, and the defense, if you have money, you can call an expert, and they can just hash it out, and the jury can decide, which is not gatekeeping. It's sort of just letting everything in and letting the jury decide, which assumes the defense has money, which the defense doesn't have in Mississippi. Maybe they could talk more about that later. So no real gatekeeping. The thing is, and Aaron is right to point this out, this isn't a Mississippi problem. This is a problem endemic to the entire criminal justice system. So lots of people talk about, I think, the Daubert gap. So in civil cases all the time, you see lawyers really fighting, because they have lots of money, about whether expert evidence should be admissible. In the criminal justice system, I hate to say it because I'm a former prosecutor, but the system is so biased in favor of prosecutors. I will tell you, as a prosecutor, I never once thought more than a minute about expert evidence, because it just seemed to me automatic, like whatever we asked for got in. Whereas I'm realizing now, years later, that the defense was always struggling, like to, there was almost no way to oppose it because things were just so slanted in the criminal justice system, where judges were letting in expert testimony and defense lawyers were almost powerless to fight against it. The most they could hope to do is call their own expert witnesses, which takes money.
Anything on judges?
Can I get may I
Yeah.
take your spot
Go
for
for
1
it.
second?
Go for
If I do say so myself, there's a really nice part at the end of the book that Radley wrote about a follow-up to your question and something you had said earlier, Bennett, about not just the failure on the part of trial judges, which is sort of what you were talking about gatekeeping, but something that gets my blood pressure up every time I think about it and deal with it, which is every day in my job, is the failure of reviewing courts and appellate courts to be, and I'll put a nice phrase with it, intellectually honest about what has happened. Anyway, there's a great part towards the end of the book where Radley, a non-lawyer, explains the Anti-Effective Death Penalty Act, whatever, AEDPA, and the perverse way that has worked to trap prisoners who are seeking relief from people like Hain and West. Anyway, you want to sort of explain that?
Sure, I'll jump in. So the absurdity, just to start off a little bit, the absurdity of asking judges to be gatekeepers of science is that judges are trained to be lawyers, right? I'm a Colts fan, I wouldn't ask a judge to come up with a game plan for, our game against Washington next week. But we ask judges to do scientific analyses. And they do it exactly like you would expect a judge to do, which is they look to see what other judges have done. And so, where science is always sort of looking forward, our criminal justice system tends to look backward. And so we get this really perverse system where trial judges tend to let everything in. They let juries sort it out. And then once that happens, usually because they feel insecure about looking into the science themselves, which understandably I would too. I'm a journalist, not a scientist. But then once one judge does it, then all the other judges just go back to that judge, and you get this sort of jurisprudential game of telephone. And this is, we talk about this in the bite mark stuff. There's one case in California that sort of is the origin of all bite mark cases afterward, and they've kind of actually even misinterpreted it, but even so, it was still wrong. And that's how bite mark evidence is accepted, in every court it's been introduced to. But the problem then is the problem with letting sort of our adversarial system sort it out is something called the CSI effect, which a lot of you probably heard of, but it's this idea that jurors, because have been conditioned to want certainty from expert witnesses. Well, the problem with that is the more certain an expert witness, the more persuasive they are to a jury, but also the more certain an expert witness, the less scientific they are. Scientists tend to actually speak in probabilities and talk about margin for errors. A guy like West says things like, indeed and without a doubt, and jurors eat it up. And so not only is it wrong to let jurors sort of sort out who the better expert is, the set of skills it takes to be persuasive to a jury is almost in contradiction with the set of skills it takes to be a good expert witness. And that's a huge problem. Then we get to the appellate level, which is what Tucker wanted to talk to me about, or wanted me to talk about, and that's, so at the appellate level, if you've been convicted with, what you think is junk science, under this law, the EDPA law, you have 1 year to file your claim, and you have to file your claim within 1 year of when the new evidence, well, let's say, you have to have new evidence. The new evidence has to have been, I guess, like sort of more than likely to have produced a different outcome by the jury, and you have to file your claim within 1 year of when this new evidence could reasonably have been discovered. Well, the problem with junk science, something like bite mark evidence or shaken baby syndrome or hair fiber analysis, is that there's no sort of set point at which there's a scientific consensus that this is now junk science. Science is a gradual process. And so what we've seen in a lot of these cases is some claimants will get shot down because they filed their claim after the first 2 or 3 studies called a particular forensic discipline into question. And they lost because the courts ruled, well, there's not a scientific consensus on this, it's still, and now they're at risk of being procedurally barred from ever raising that claim again. Others have waited until there was a strong scientific consensus, and the appeals courts in those cases say, well, you waited too long, you should have filed your claim within a year of those first couple studies coming out, now it's too late. And this happened with Hain. Hain was declared sort of discredited by the Fifth Circuit a few years ago. It was the first time any appeals court had ever said Hain was a discredited expert witness. But they also said that, citing my article from 2007 and a couple of court decisions from 2008, 2009, that the claimant should have filed, he was way past his 1 year sort of limit. Well, again, there's so much wrong with that because that very same appeals court, less than a year earlier, had upheld a challenge to Hain's credibility. And so they basically put these defendants in an absolute can't-win situation. Not to mention the absurdity of, this wasn't a death penalty case, it was in Louisiana, it was he'd been sentenced to life without parole, so he was, filing his claim pro se, so like the idea was that he, from his prison cell in Louisiana, he should have had a subscription to an obscure libertarian monthly magazine called Reason, and should have known that, had read my article and thought, aha, now I should file my claim. I mean, the expectations that this law puts on people who have been wrongly convicted, it's absolutely outrageous, and it's hard to kind of explain the outrage because you get so deep in the weeds of kind of the legalese, the jurisprudence that's going on. But these people are trapped. If you've been convicted with bad junk science and you don't live in Texas, which actually has a pretty good system now, the hopes of you getting a new trial, short of DNA testing, are pretty slim.
Can I add one more thing about judges? Because I think in the background of all this is, the state judges are elected. They're almost all exclusively former prosecutors if they have any criminal experience at all. Judges, the last thing they want to do is sort of overturn a conviction of a murderer. So there are all these sort of things weighed against sort of the interest of justice or sort of objectivity.
Yeah. Well, one just example real quick, I think it really illustrates the problem. There's a case we talk about in the book, the Tyler Edmonds case. This is a 13-year-old boy who was being tried as an adult for killing his sister's husband. And the prosecutor's theory was that neither of them had the guts to kill the guy on their own, so they waited until he was asleep, and then they both held the gun and simultaneously pulled the trigger together. Now, who knows if that happened or not, but Dr. Hain got on the witness stand and he said he could tell by the bullet wounds in the body that there were two people holding the gun that fired those bullets. Now that's absurd, right? It's transparently absurd, yet he gets convicted, the Mississippi Court of Appeals upholds it, the Mississippi Supreme Court actually initially upholds it, and then one justice wrote a dissent so blistering that they re-voted and finally threw out the conviction. But during the trial, Tyler Edmonds' attorneys made a Daubert challenge, and they wanted to have a hearing on whether this two people holding the gun theory there's any science behind it. And the judge not only turned them down, he didn't even grant them a hearing. There wasn't even a hearing on that particular thing. It was so self-evident that this was scientific, we didn't even need a hearing. Meanwhile, Edmonds had initially confessed because his sister had sort of guilted him into it. Basically, she said, they're going to kill me unless you confess, and you're a minor, so therefore you're not going to, they're not going to go after you as hard. And he confessed basically to save his sister, and then he immediately retracted his confession. And the defense wanted to call a witness to talk about false confessions and how Tyler Edmonds was the poster boy for false confessions. He was young, he was emotionally sort of behind for his age, he'd been separated from his mother during the questioning. And the prosecution asked for a Daubert hearing to challenge the scientific validity of the false confession expert. The judge granted it, gave a one-day hearing, and ruled for the prosecution. So Hain was allowed to give the two people holding the gun theory, but they couldn't put on somebody to testify about false confessions. And that is sort of emblematic of the way these challenges tend to go in criminal trials.
This is a good time to bring in prosecutors and defense lawyers, I think, then, as actors. Neither of them come off very well in the book either. There are some defense lawyers who make some gestures, but there's also a kind of remarkable failure to identify even basic, although tricky things, like the fact that the certification that they hold is actually not from the right credentialing organization. It's from kind of this made-up one that sounds really similar. What about prosecutors? And I should add, too, that the main prosecutor in both cases is a kind of Faulknerian figure, Allgood, ironically named. He's propping up these witnesses at one point by likening West to a scientific mind akin to like Galileo or something. Talk about their role, prosecutors and defense lawyers more generally, what we would hope they would be, maybe Bennett could address, and what they are. Maybe Radley and Tucker could get into.
You're up.
Oh, I thought Bennett was going to go first with prosecutors. As Professor Murphy said at the beginning, we were colleagues at the Public Defender Service in D.C. for years, so I have a soft spot for defense attorneys. That said, the defense attorneys in most of these cases are abjectly terrible, and there are reasons for that. Mississippi, like a lot of states, has a severely underfunded public defender system. In fact, doesn't have a statewide public defender system. That said, there's also, I think, I'll be interested to see your all's reaction, Bennett especially. We were very spoiled in DC, and I don't know what your experience was here, but there was a culture at the Public Defender's Office in DC and in DC Superior Court of really high-level litigation. You would file Fourth Amendment motions in every case where there was a potential Fourth Amendment claim, or even when there wasn't, in order to get discovery. And there is just not that, the first thing I'd say is there is just not that same culture in a lot of places across the country. And that really hollows out so much of what is absolutely necessary about defending a case. And let me just say, let me give an example. When you don't have that culture, then what happens is there are various corrosive effects, one of which is the introduction of this nonsense bullshit forensic disciplines like bite mark matching. And when that gets a hold in a jurisdiction, it is incredibly difficult, as you all said, to eradicate it. And let me just give you sort of an example. We finished about a year ago an evidentiary hearing in a death penalty case, Eddie Lee Howard, in this same county, same jurisdiction where Brooks and Brewer were. Mr. Howard was convicted almost exclusively on testimony by Michael West. It's absurd that we had to have a hearing. It's just patently absurd. But you know, the Innocence Project lawyers, they all flew down, we flew in. I mean, it cost us thousands of dollars to put on this farce. I mean, it's just obvious what should happen. But when you go back in time to that trial, 2 weeks before Mr. Howard went on trial, 2 weeks, in the same courtroom with the same prosecutor and the same judge, they had just finished a capital murder trial. The main piece of evidence in that capital murder trial with the same defense attorneys was bite mark evidence. In that case, Dr. West matched the bite mark of the defendant's dentition to a bologna sandwich. There's just simply no way, if you follow me, once you don't have, a culture of aggressive defense lawyer, any number of things happen. One is that forensic science, nonsense forensic science gains a foothold. There is no way that judge in Mr. Howard's case, and that they did sort of have an argument about whether Dr. West whether his opinion was legitimate or not. There's just no way that judge is going to say on that day, you know what, you guys have convinced me, because they didn't, right? And there's no reason almost for them to put up a fight. There's no way that judge is going to say, oh, you convinced me today. Yeah, I'm not going to let that in. Because that would implicate not only that case, it would have implicated the bologna sandwich case from 2 weeks before, and it would have implicated Brooks and Brewer. So that's just one example of, a lack of a vibrant, robust criminal defense bar. There's any number of things that happen, one of which is the introduction of baseless forensic science.
So, you guys may have heard this, that the job of, and I don't know, you can remind me where the quote comes from, the job of the prosecutor is not to get a conviction, but to ensure that justice is done. So clearly, I'm gonna go out on a limb and say that was not the mantra in Mississippi at the time. The prosecutors were clearly out for conviction, and it seems like they were enabling sort of like injustice rather than justice. But again, there are all these things in the system that sort of facilitated that. So the fact that the prosecutors are elected facilitates that, because you get elected by being tough on crime, not by looking too closely at the evidence to see if the evidence really points towards conviction beyond a reasonable doubt. The law is slanted already, so it's not just prosecutors, it's actually the law that we get from courts that basically makes it so that you could have 2 cases in the space of the week where it doesn't matter what the evidence is, the prosecutor's gonna win each time, because the law is slanted that way. You just make different arguments. You always have an argument from the law that's gonna work for your benefit as a prosecutor. Tucker was just saying, the defense lawyers sort of dropped the ball. The prosecutors in this, I can only imagine that they knew so much of the evidence that they were introducing should not have been introduced, especially when they're calling Haynes as a witness to talk about things that are outside of the normal realm that even a medical examiner would talk about. So when he's talking about, the direction of bullets, I don't normally think of a medical examiner sort of doing that to the level Haynes was. But that sort of speaks to the system. It also speaks to 2 other things for me. One is the failure of prosecutors even to ask questions, which makes me wonder, even if you want to be a good prosecutor, do you go in and just get corrupted by the system? One question I actually had for the 2 of you as I was reading this book, and this is sort of going off on a tangent, for Dr. West, the country dentist, it seems like every time he was summoned to a scene, he would find bite marks. And all I could think is, wait, is everybody, like, if you're shooting somebody, you're gonna bite them? If you're drowning somebody, you're gonna bite them? If you're raping somebody, are you gonna bite them? He was finding bite marks, it seems, left and right. And I kept thinking, wait, aren't the prosecutors even curious to know, like, how is it that every homicide has a bite mark?
We actually, one chapter, the title for one chapter that we later changed, though, was something like the 1990s, like a decade of ubiquitous biting or something, because all of a sudden with Michael West, now everybody's biting everyone. It was,
My son went through that stage.
So I want to have time. Well, I do have a whole list of questions about hope for the future, but maybe one of you will ask that. I want to make sure we have time for your questions. So I believe we have mics in the back. I think they may get moved up. I'm not sure. So you're welcome to ask your questions. I'll wait till I see any hands. If you want to raise a hand, yeah, or if you want to.
So thank you all for a great panel discussion. I wonder if we could broaden the discussion a little bit beyond Mississippi and just talk about standards of evidence, admissibility for forensic evidence versus scientific validity. And if you could talk a little bit about the obstacles to changing the standard in Daubert, to talk a little bit about the President's Commission report and how that was rejected, and what are the prospects for changing the law to minimize or, if possible, eliminate the influence of junk science?
I'll just jump in first because it's a pet issue of mine. Bite mark evidence, every scientific body that has reviewed bite mark evidence has rejected it. They've rejected the two main premises of bite mark analysis, which is that human dentition is unique. There's no science to back that up, that we all have a unique bite. And two, that even if it is unique, that human skin is capable of recording a bite in a way that preserves that uniqueness so that you can identify people. There's no science to back that up either. Every single scientific body that's looked at it has rejected it, and I think there have been 4 or 5 now. Yet, to this day, every single time someone has challenged the scientific validity of bite mark evidence in court, they've lost. Every single time. There's something wrong there. There's definitely something wrong there when science says this is completely illegitimate, and yet the courts can't bring themselves to reject it. And I think this goes to something Tucker and I talk about in the book, we talk about a lot actually, which is why Mississippi hasn't done anything about this. Why hasn't there been an investigation, at least into West? I mean, who everybody agrees is a fraud at this point. There's still people who defend Hain. And I think the reason why you haven't seen the kind of outside blue ribbon panel, looking at other cases, because there are undoubtedly innocent people in prison because of these guys still. And some of them we know, and there are countless we probably don't. But if Hain testified in thousands of cases, and he testified in 80% of the homicide cases over 20 years for Attorney General Jim Hood, who used Hain when he was a prosecutor, for the Mississippi Supreme Court, for anybody in the Mississippi legal system, or the federal system for that matter, that reviewed a lot of these cases, to order that kind of review would require them to basically admit or come to terms with the fact that this system that they've dedicated their entire lives to and that they believe in is a fraud. That's a really hard thing for people to ask somebody to sort of wrap their brain around. I mean, imagine if you're an attorney, a judge, you go into your work every day, you think you're contributing to sort of the dispensation of justice, and we're asking them to say, no, for the last 20 years, this guy's testified in 4 out of every 5 homicide cases, and every single one of those cases, now not all those people are innocent, of course, but every one of those cases is tainted and needs to be reviewed, and that is a huge thing to ask, somebody who has given their sort of professional life to the criminal justice system. So I think that's a huge thing, and that goes beyond Mississippi. I think just in general, when we talk about forensics, I mean, when the Obama administration, when Obama's Presidential Commission on Science and Technology issued their report on forensics, it was a stinging, damning report written by actual scientists. And Obama has celebrated this as sort of one of the triumphs of his presidency, but his Attorney General Loretta Lynch rejected it. She had said they had no plans to implement that at Justice Department. First thing the District Attorneys Association did was reject it, said they had no plans. And, again, to ask sort of people who are immersed in a prosecutor's culture to admit that all these pattern matching fields of forensics are inherently flawed and have been presented to juries in ways that aren't backed by science. Again, it's asking them to like admit that they made a hell of a lot of mistakes over the course of their career. And that's a really hard thing to ask people to do.
Front.
Thank you so much for speaking today. I'm a 3L here at NYU, and I had a question, I guess mostly directed at Professor Capers. It seems like institutional change is very difficult, precedential change is very difficult with judges. So once it gets sort of introduced or brought forward, maybe you've already lost the war. How would you address talking to and maybe changing cultures in prosecutors' offices so that they become the gatekeeper? So if we can't actually functionally change it once it enters the arena, you prevent it from having them utilize it or actually take advantage of those perhaps slanted rules and sort of self-police.
You're asking one of the hardest questions that so many of my friends have been wrestling with for a long time. How do we change the culture of prosecutors' offices? One thing that's going on around the country is you have more progressive individuals running for office and winning. So I was pleased to read that even Olga, the elected prosecutor in this case, who is so sort of turned a blind eye to so many injustices, was eventually voted out of office. So much seems to turn, for me, on sort of citizen involvement. Like, the system in Mississippi, like we've talked about prosecutors, defense lawyers, judges, coroners, at the end of the day, I still feel like it's partially a problem with just the population in Mississippi and the population of this country. Like, how do you get them motivated? Like, with the Attorney General Hood refusing in Mississippi to open up, like have an integrity unit to look at past convictions. The only reason he can get away with that is because the citizens aren't clamoring for the Attorney General to open up an integrity unit. If the citizens were clamoring for that, it would happen. So a lot of changing prosecutors' offices is in part changing us, which I don't know how we do that. but you know, hopefully with books like this, like if we made this book mandatory for every law student in Mississippi,
I'd support that.
At full price, of course.
that might actually change what happens when young people become assistant district attorneys. Because instead what happens is we sort of get locked into like this idea of like, oh, you know, we're just gonna do what our predecessors did. We're just going to, you know, think every person who is arrested is probably guilty, and we're just gonna just put on blinders and just go full steam ahead. So it's a great question. My answer is unsatisfactory. I'm sorry.
I just want to add really quickly, because one of the interesting things that's also in the book that Tucker alluded to is there's a political story about the Office of the State Medical Examiner and what happens as the legislature is actually trying to initiate reforms, including up till quite recently, where I guess they pass a law that says you have to have kind of real credentials if you want to be a medical examiner. And Hain comes along and says, well, this is kind of like their credential. You say, is this good enough? And it actually takes state officials, you know, bureaucrats essentially saying rejected. I keep doing that. So there's also this interesting tale as they're bringing in at a couple times real people who are serious, who are trying to do their jobs, and there are political forces aligning against them among the coroner, this death investigation system that's a relic of the past, among the district attorneys who are saying, if I have to choose between the person who is really fast with results, because they're doing 1,000+ autopsies a year, and always seems to agree with my guy. When I write them and I say, I think it's this guy, they always write back, it's definitely that guy. Versus the person over here who can't even tell me half the time if it was a homicide, takes a lot longer, you know, is gonna answer questions of the defense lawyer if they ask for them. That's a really important structural piece of the political process, because there had been political will, and yet these vested interests were able to undermine it. More of your questions? Yeah?
Hi, thank you very much. I'm curious about lie detector tests, whether you've looked at those as well. It seems like something which is still fairly ubiquitous, or at least widely trusted in the public, and yet some research seems to be showing is, you know, no more than 50% accurate as well. Is that a topic that's come up in your work as well?
Yeah, it's widely, I don't know about I think you're probably right, trusted and certainly known. Even in the Oval Office, evidently, there's been talk recently of lie detector tests.
Break the machine. If they-
Yeah. I think it's safe to say, notoriously unreliable. And in fact, Levon Brooks was subjected or agreed to a lie detector test in his case, and was found to be deceitful about his involvement in the homicide. Now, it wasn't admitted. Their lie detector tests are inadmissible in Mississippi, like they are, I think, in every jurisdiction. But I do think the other piece to your question, I think, is that lay people, I think, tell me if I'm wrong, generally, I still believe that there's something, valid or helpful or useful about lie detector tests. And I should say more than just lay people. A lot of law enforcement still think the same thing. I've yet to be, I remain unconvinced.
Yeah, I'd say I don't even like the term lie detector. It's a polygraph because they don't really detect lies. They do detect nervousness but you're being questioned by police about a murder. There's lots of reasons to be nervous, even if you're innocent, especially if you're innocent, maybe. But yeah, they're not admissible in court. But they are admissible. They are used for like intelligence screening, and I know a lot of like
Pre-offers.
Fortune 500 companies use them. Yeah.
Yeah.
Thank you for being here. So similarly, there's a lot of trust in DNA evidence. And I think this past summer, the Marshall Project published a really stunning story about a man whose DNA was found at a crime scene simply because the same day he had like the heart monitor finger machine on him as the victim. And that certainly made me bristle. And so you talk about there's been sort of some debunking of the bite marks. But DNA is such a holy grail for so many people and for juries and for judges. Do you see that same kind of distrust starting to build towards DNA, since DNA can kind of tell a little part of the story but not the whole arc of the story? Or is DNA sort of a totally different beast that's going to be virtually impossible to debunk in that way?
I think that's a question for our moderator, right?
I feel like you guys could answer.
I mean, you literally wrote the book on it, so.
You're in the ground.
I'm going to sort of keep an eye on you as I'm answering this question. Look, I'm a equal opportunity forensic science basher. I just think, look, almost every single one of these disciplines, regardless of the basic data that would declare some more sound than others, every single one involves any number of complications, including humans, but who are both doing the testing, doing the evidence collecting, and so on. So in some ways, yes, DNA is a sort of holy grail, at least in the sense that it was developed outside of law enforcement, that it does have probabilistic data which support it, unlike most of other forensic sciences. That said, DNA analysis is not immune from many of the same vagaries that have infected other sciences, especially, and this gets into a lot of what Aaron is commenting about, every day, as DNA develops and new techniques develop. They are constantly pushing the envelope about what's legit, what's admissible in court, and so on. And I think you have to keep your eyes open. I don't think there's a forensic discipline that passes muster today and from time immemorial.
I mean, I will say, if you're talking about single source DNA, like you're talking about blood or semen, and you're testing it and there's only one contributor and, it's pretty reliable. Okay. I'm going to you can just fact check me as I talk here. Where we get into problems is with like touch DNA, and it's where you have, how many people have touched this microphone in the last week, and let's say it becomes a piece of evidence in a crime. Now you start getting into, they have sort of algorithms that private companies are developing to sort of, try to sort of fish out sort of what DNA we need for this particular, to prosecute this particular crime or to exclude somebody from this particular crime. And that's where it gets, now you have humans sort of deciding what DNA is valuable, what DNA isn't, and that's a judgment call, it's subjective. Now you're getting right back into kind of the pattern matching stuff where you have somebody who's projecting sort of subjective values on, what is kind of an objective science or mostly an objective science. And even scarier is a lot of those algorithms are proprietary. And so, defense attorneys aren't even allowed to hire their own experts to look at them. And that gets really scary, I think.
So we're running out of time, so I want to wrap up. And I'm going to ask the panelists if they can each say, one piece of advice they would give either future prosecutors or future defense lawyers, or maybe even just future jurors in the room about how to sort of safeguard the integrity of the criminal justice process in whatever role they're serving. While you think about that, I'll just add in respect to the comment that was made, one theme I think you see throughout all of these disciplines, I agree entirely with what Tucker and Radley said, is the way in which information is given to the jury, particularly when it is the key critical fact of identification. What does it mean that there's a match? Is there a match? All disciplines, even DNA, have big problems with that. In DNA, the problems are more sophisticated because they use these probabilities, and what probabilities you use and how you express it is a much more complex question, whereas in some of these disciplines, they were just making it up. This is the suspect, or 1 in a billion, this is the guy, and it was just a completely fabricated number. West, I believe, uses this catchphrase, indeed and without a doubt. You see other scientists saying things like, with a reasonable degree of scientific certainty, and those are just garbage phrases. And prosecutors don't necessarily have their, sounds good. It's not like you immediately fraud alert goes up, and yet it took until a National Commission on Forensic Science said, this is a garbage phrase, it means nothing, it should never be used in a courtroom, that I think even well-meaning prosecutors first realized, I might have to police my experts here. I can't trust them to tell me what the science is. I have to make sure I myself am responsible, and I think that's an important thing to remember. So going down the road then on kind of other pieces of advice you would give.
I'd echo what Bennett said in response to your question, I think, about all of us being more fully participatory, both in the criminal justice process generally, whether it's in local elections, whether you end up in a prosecutor's office, defense attorney's office, you end up as a juror, whatever fully participatory means. I think that's critical. I'll say one thing, which is, I won't go on about it, but the Levon Brooks case in particular happened in this dark corner of Mississippi. We spend some time in the book talking about Noxubee County, what it was like during the 20th century. And in some ways, his trial was fully participatory. He had African Americans on his jury. He had white folks on his jury, all of whom, and the story of African Americans participating in a petit jury in Noxubee County, Mississippi, is a story of real triumph. And yet, for all of us, not just those folks, and yet Levon Brooks got convicted and sentenced for the rest of his life for something he didn't do. It was likewise a sort of tragic failure because we weren't, among other things, fully participatory in what was going on.
My advice would be, no matter whether you're a jury, whether you're a voter, whether you're a DA, or you get involved in some sort of law enforcement elsewhere, always remember that incentives matter and incentives are important. Ask yourself, are we structuring sort of success, our definition of success in a way? For example, are we telling police officers that they're successful if they make so many arrests a month or so many arrests a week? Are we telling prosecutors, your success depends on how many people you convict or your conviction rate, not necessarily, maybe we should be also looking at the people they don't prosecute for a lack of evidence or because it isn't in the interest of justice. The incentives in Mississippi we told you about, Dr. Hayne, we say this in the book, if it hadn't been Dr. Hayne, it would have been somebody else because the system was incentivized to create somebody like Dr. Hayne, to monopolize the system because prosecutors could pick what doctor they sent the body to for an autopsy. And so if a doctor came back and said, that's not how it happened, or more likely, there's just not enough evidence for me to say that that's how it happened, a corrupt prosecutor is immediately going to go to another doctor. But even a conscientious prosecutor, we all tend to migrate toward people who make our jobs easier, and those are the people we want to work with. But we need to be cognizant of sort of the incentives that are in play all throughout the criminal justice system, I think.
And I agree wholeheartedly with what Bradley and Tucker just said. The only thing I would add, speaking to future prosecutors, is, again, remember, your job is to do justice. Always have that front and center. You know, if you find yourself in an office where you have suspicions that's not happening, you know when to leave, know when to be subversive and resist. You didn't hear that from me. But you know, at the end of the day, you know, it's your job to do the right thing.
Well, you did the right thing by coming today. So thank you all for being here. Let's thank our panelists as well.